Welcome everybody to Free to Thrive's training. We are just going to take a few minutes to let everybody into the room. All right, and while we were waiting, we have a poll up on the screen. I just want to know where you're coming from. We'll be starting in just a minute. For those of you just joining us, we'll be starting in just a minute. So we have poll number 2 up. Just like to know a little bit about who our audience is. We're still letting a few people into the room, so we'll get started in just a minute. Okay, and we're about ready to get started now. Okay, well, welcome everybody to Free to Thrive's a trauma-informed approach to working with human trafficking survivors in matters of family law. We are really excited to have you attend this training. We will have a number of speakers today. Mary, if you could go to the next slide. Just as a brief introduction, oh, sorry, back one. As a brief introduction, everyone's muted. We can't see your videos. For those wondering, the slides and an outline of this presentation will be made available to you after the presentation. We encourage everybody to ask questions throughout using the Q&A feature, and it'll help us organize the Q&A session at the end. Reference materials that we reference during this presentation will also be provided along with the slides, and we are in the process of obtaining MCLE approval for this training from the State Bar, and if and when we get that, those certificates will be mailed out. And really excited for the speakers today. So my name is Nicholas Moore. I'm the Senior Staff Attorney at Free to Thrive. Joining me today will be Jan Maiden. She's a family law attorney in San Diego, over 18 years of experience, and Mary Mosany, who is a Free to Thrive board member and family law attorney at Cage & Miles LLP here in San Diego. And also we will be joined by a thriver, a survivor of human trafficking, Gabriella. And we're not going to show her picture or use her real name for privacy considerations, but we're really excited for you to hear her perspective because we think it's definitely something everyone should hear. So real quick, I'm just going to get started by talking about who are survivors of human trafficking and what is human trafficking. And this is really the abridged version of our Human Trafficking 101 presentation that we've done a number of times. If you're interested in learning more about human trafficking and the legal system, we have a recorded version of this training for free on our website, www.freetothrive.org, and links will be provided to that at the end as well. We encourage you to visit our website for all of our trainings, which are all free and all recorded like this. Just to begin, what is trafficking? Trafficking is the extraction of sex or labor through fraud, force, or coercion. This is distinct from smuggling, and that smuggling is transporting a person over a border or transporting something over a border. Trafficking is really exploitation of a person. So when we talk about who are trafficking survivors, there are two main types of trafficking survivors. There is sex trafficking and labor trafficking. Sex trafficking is defined as if it's underage commercial sex, that is sex trafficking, regardless of the victim's belief in the voluntariness of any of their actions. Involuntary commercial sex or exploitation of a person's status of a commercial sex worker is also a form of sex trafficking. We mention this because there are voluntary commercial sex workers. Sometimes people get involved in commercial sex voluntarily, and oftentimes trafficking victims do not identify as trafficking victims because they began commercial sex activity voluntarily, and they believe that exploitation that happened later to be part and parcel of the work. Even in well-regulated industries such as pornography production, trafficking still happens frequently. And in San Diego specifically, there's a very famous case that just happened, got national attention, involving the pornography website girlsdoporn.com. And the owners and founders of that website are currently being prosecuted by the U.S. Attorney's Office for human trafficking. Labor trafficking is an exploitation of a person's vulnerability for free or cheap labor. And those vulnerabilities include, but are not limited to, a person's immigration status, economic status, and gender or sex identity. And so today what we're going to be talking about is really trauma-informed lawyering and what that involves. And perhaps the most important thing a lawyer can do is be cognizant of the fact that human trafficking survivors have suffered great trauma. And one of the ways we can be cognizant and account for that is by creating a safe space for them to feel comfortable engaging in the legal process. At Free to Thrive, we're a mobile legal clinic. So we go where our survivor population is. We come to them. We want to make access to courts and access to the law convenient, and we want to do it in a location where they feel safe. It's important to recognize that the court process itself can be very re-traumatizing. And we're going to talk a lot more about that throughout this particular presentation. It's also important for lawyers to recognize privilege. And I say privilege because I think it applies very broadly and a little bit differently to everybody. From my perspective, privilege means that I need to be cognizant of the fact that my background, my upbringing, is a very privileged background and upbringing relative to a lot of human trafficking survivors. For many of our clients, I look like the person who either exploited them or purchased them. That's something I have to be cognizant of. The other privilege that all lawyers should be cognizant of is the fact that it's a privilege to be a lawyer. It's a privilege and a service industry to work for individuals. Human trafficking survivors can be sometimes a challenging population to work with, and we'll talk about why that is, but mostly it's because of their trauma. And so a part of our privilege is recognizing the impact of this trauma. And finally, I say privilege because attorney-client privilege is one of the most sacrosanct privileges that we have. And it's what we can use to help explain and generate some trust with a survivor population. Survivor or trauma-informed lawyering also requires being mindful of some of the narrative issues that happen with survivors. So when a survivor tells their story, their narrative may be disjointed and they may lack memory and they may have difficulty establishing corroborative evidence. It's important to understand how this interacts with the survivor's ability to try and seek legal action. Another thing is the potential fear that they might have of legal liability for their own actions. Very frequently, survivors are coerced into doing illegal acts by their exploiters or their traffickers. We're going to get a lot deeper into these issues, but I think an important place to start is to hear a survivor perspective of the legal process. And so you're going to hear from Gabriella now.
Thank you, Nick, and good afternoon, everybody. So from the survivor perspective, we are very afraid when we're going into the courtroom because you have to think about, this is somebody who has done trauma to us, this is somebody who has harmed us in many different ways, and it can just create a lot of scared feelings. I know for myself, I experienced a lot of those and just those uneasy feelings. Someone who's been violent towards me and just done a lot of bad things to me. We may appear disorganized and extremely emotional. For that, it's just hard to keep track of everything that's gone on. Like Nick mentioned, memory is something that, I'm so sorry, my dog. Memory is something that can jog our thoughts, and just remembering the events and stuff that has happened to us, it can just be awful for us at that point in time. Going back and forth, questioning whether I want to give a different answer, if people are going to believe us, afraid of that is a big thing as well. Maybe even wanting to dismiss the restraining order. I know I struggled with that a lot throughout my case. I just felt like people wouldn't believe me. I felt like extremely guilty for causing all of this, and just wanting it to stop because I was experiencing all that trauma all over again. Terrified about the unknown. With that, I know being trafficked, it's something that we're always going through. We don't know what's happening next. We always expect the worst. So I know that's a big feeling and creates a lot of uneasy emotions. Now in court, I know for me, things moved really fast. Sometimes I would have to ask for breaks. I wouldn't understand the language, the legal language. That was a huge barrier for me, but it was really easy for me to talk to my lawyer and get that clarity about things that were being said that I didn't know. Also, sometimes I felt like I wanted to minimize my trauma, and I blamed myself, and I felt dumb. How do I look going into a courtroom and saying all this stuff that happened to me, and people are going to look at me like I allowed that to happen? Also, it could be really triggering. I know just bringing up all of those events and stuff like that, it could cause me to just be unstable emotionally, mentally, and in many other different forms. And stuff that lawyers can do to help us survivors is to have a clear roadmap. I know that really helped me out a lot, was when my lawyer, he gave me a timeline of events that would possibly happen, when stuff would go on, what it could look like if it was to go good, if it wasn't to go in my favor, focusing on outcomes and allowing us to make the choices. I know I felt super empowered when my lawyer would give me options and allow me to make those choices for myself, because that's something I wasn't able to do when I was being trafficked. Also checking up on us survivors at that time. I know it could be a lot when we're drafting our own declarations. For me, I know it took months for me to just relive all of that. And trying to relive all that, it seemed inconsistent because of a lot of the time there was drug usage, just for me to self-medicate to feel better while I was being traumatized, and still to this day, it affects my memory heavily. So the last thing I want to stress is just patience, having that patience for the survivors. I know that was critical for me, and that's what helped me to build trust with my lawyer, especially, was just him having that patience for me and allowing me to move at my own pace and not rushing.
Thank you, Gabriella. Next, we're going to have Free to Thrive board member and family law attorney Mary Moseny talk about family law applications to survivors.
All right, thank you so much, Nick, and thank you so much, Gabriella, for your perspective. And of course, thank you to Free to Thrive for all the work that you do and for putting on this training. And I'm excited to participate. So quickly, I just want to go over an intro to family law needs of survivors. You'll see, for those of you who practice in the family law arena or familiar, you'll see that a lot of these issues are the same. The only thing is that the dynamic is going to be different in terms of complications with your case or how you approach certain issues. We know that family court is emotional and can be very difficult for clients, even with a regular, quote unquote, regular divorce or paternity case. But with survivors, we are looking at everything from a different lens, and we are hopefully being as trauma informed as possible in how we approach all these issues before you. And we'll go through most of these, not so much property rights, but we'll touch on these throughout the presentation on how we can be trauma informed on all these issues. One specific interesting issue with that's different than regular family or divorce cases or paternity cases are that, the other party could be the abuser, the other party could be the trafficker, the other party could be a sex buyer, or the other party could just be current father or mother on the case. And for the purpose of this presentation, I'm going to refer to my client as she, and the other party as either the father or husband, just for ease of reference. Okay, so we wanted to touch on and have a slide just kind of acknowledging the fact that we are living in strange times. We are living in a time where COVID-19 is present. Everyone is social distancing. I don't know about every attorney in this on this call and in your jurisdictions. Here in San Diego, we are doing virtual hearings by video and phone in family court. State of California has some in person, and so I'm not sure what your jurisdiction is doing. But in light of that, we thought it'd be good to touch on that first, and understanding that it's going to be a little bit more difficult to be trauma informed when we're practicing social distancing. For example, accessing a client's file at court, if they already have a court history and you want to know what it is, it could take a little bit longer to get access to because they're practicing social distancing at the courts, and it could take longer to get access to that. Also in California, we refer to cases that are not dissolutions that are not married, where the parties are not married, where they just have a child together as paternity, and those are confidential. So it's another hurdle getting access to those cases if you're not the party or the attorney of record. We have a new e-filing system in San Diego Family Court. We're kind of late to that, but there's some delays in e-filing that was set up in light of COVID. And also it's just going to take a lot longer to get your filings back from court. And also your hearing date is going to be set out probably longer than usual. I'm not sure about other jurisdictions, but our family court calendars are very impacted even before COVID-19. And we went 10 weeks with our courts shut down and no hearings were happening. So we're rescheduling 10 weeks of hearings, plus also, everyone's new filings. So you have to be aware that your client's hearing might not be months from now and could even be in 2021 at this point. So we're dealing with that. You're going to want to figure out how to prepare your client ahead of time for these virtual hearings. What's the virtual hearing going to look like? What is it going to be like calling in or doing a video conference to your hearing? Who will, quote unquote, be there as well? And how will your client be participating? And I apologize for looking down, but I'm looking at my notes here. We'll dive a little bit deeper into that in future slides, but does your client have the proper access to proper technology and equipment to do that? Do you maybe want to, if you have office space or an extra office or a conference room, to have them come in for their hearing in a separate room so that you can set them up for that? One other burden or barrier for COVID-19 is and in terms of being trauma informed, is being there emotionally for your client during a hearing. Obviously, you're not going to be able to do that in person because you're going to be both on a video call, right? Normally, if you're in a hearing at a restraining order or a custody hearing, you can, if you're noticing that your client is getting stressed out or having a hard time, you can put a hand on their shoulder and let them know it's going to be okay. Pass them a note. There's those in-person, take a break, go out into the hallway, give them a pep talk. And that's not as possible while you're on a virtual hearing because you can't talk to your client without everyone hearing. So if you do need to take a break for your client, which we'll talk about, that might be muting yourself, going off the video, going into another room, calling them, and that could delay your actual hearing and the time set that you have for your hearing. So just being aware of that is important. Discovery, do we have that on here? Yes, conducting discovery. I mean, written discovery is pretty much the same. California, we're doing virtual depositions, but quite frankly, I don't have much else to talk on that because, you know, we're all learning how to handle discovery issues while social distancing at the same time. But presenting evidence in your hearing, I mean, is there going to be a different effect on the judge because you're in a video and a phone conference? I would say probably, absolutely. You're not there in person, and it's going to be difficult to present your testimony, especially if, you know, there's delays or kinks in the video and the streaming. And so you have to think about that. You're going to also want to think about how ahead of time you're going to get your client or any witnesses their exhibits, you know, if they're going to be referencing those, and making sure everyone has a copy of them so everyone's on the same page, you know, in our special locations while doing that. So there's just some things you're going to want to think ahead of time and prepare your client for. Overall, the most trauma-informed thing you can do with that is just, you know, keep your clients updated, keep them informed of what's going on, keep them updated on any changes, and things are constantly changing, and just let them know that you can go over the processes as many times as they need, and that we're all going through this together. This virtual platform is an experience that we're learning together. So just keep that communication open. Let's see. So we want to go over some considerations for working with your clients, and these are things that I think that are good to have from the onset of any case. First, we want to be able to set some realistic expectations. I mean, I think we say this a lot for just any divorce case. In any case, you want your client to understand what's likely to happen, you know, and prep them ahead of time. But especially for survivors, it's important for them to know that this is not a criminal court. Family court has a specific purpose. That's not there to put anyone on trial in terms of their trafficker or a sex buyer or anything like that. They're there for very specific family court reasons, whatever it may be, and we'll get into those. California is a no-fault state. I believe many states are at this point, and you know, so we don't consider, you know, why a couple is separating or divorcing. That's not going to be relevant evidence. History of abuse, trafficking, or sex buying will only be relevant in certain situations. So we'll dive into that. And so just setting your client's expectation for understanding that that's not going to be the focus of family court if it's not relevant. But we'll get into that. This is not a place for, you know, punishment or symbolic victories. For example, when it comes to custody, I had this, and I can give an example later on, but when you're talking about custody, you're looking at the best interest of the children. If you're not currently or not recently been trafficked, or if it wasn't, you know, the father of the child isn't someone who trafficked you and it's not currently affecting the children, the court's not going to find that relevant. And as hard as that is to say, you got to find a sensitive way to tell your client that, right? To tell them that the court's looking at what dangers are the kids facing now. So maybe a history of trafficking isn't necessarily going to be relevant. So just having them understand what are the issues in family court and what can family court do. Let's see. Oh, and letting your client know that it's a public file. So in California, all divorce cases are public and accessible to the public if they want to go request a copy of the file. So that's important for when they're writing their declarations in terms of, you know, what they want to say, their financials, their identifying information, and so on. In California, paternity cases, like I said, are confidential. That's when the parties are not married and it's just they have children together and they're handling parentage and custody and support issues. Timing, lifetime of a case. Again, even pre-COVID with delays with the court, divorces take a long time. Even paternity cases take a long time. Even just a simple motion for custody orders and support orders can take a long time with continuances, setting trial, and having impacted calendars. So you want to be clear that this is the start of your case, if it is the start, and it can go on for months, it can go on for years. And you want your client to reassess that they're going to have that emotional toll the whole time, right? You're going to have court lingering over your head, upcoming court dates lingering over your head. And so you want to be clear with them of what they're requesting and what they're going to be getting into for the long term. Sometimes you want to settle a case because it's just not worth going another year, right? I know Gabriella talked about, I just want to dismiss the restraining order. And, I can understand why a client would feel that way. And so it's good to always be doing cost benefit analysis with your clients as you progress through the case. And a cost is definitely, there's emotional costs, right? Emotional tolls, and you want to be clear with them about that. I have a note about zealous advocacy that kind of parlays into zealous advocacy. We're taught to be zealous advocates for our clients. You know, family court is a very emotional place, and sometimes we use that emotion to our advantage. And sometimes it's just good to know when to not use that emotion to your clients, try to use it towards your client's advantage, because, you know, they're going to be re-traumatized in the process. So you know, there's a time and place for using high emotions and not using those, and trying to avoid those the best you can for your client's sanity. And undivided duty of loyalty, that's there to talk about how, you know, sometimes you have a client where maybe you're talking about custody and you're just, you know, you might think, okay, this client is probably not the best parent to have primary custody right now, or probably not the best parent to have 50-50. Maybe some things need to change in order to get them to that point so that they can, you know, care for their children. But that's not, you know, if that's not what your client wants, then you still have to advocate for that primary custody request or the 50-50 custody. And we can get into that a little bit longer later. But, you know, there's a difference between being clear with your client about a likelihood of an outcome, and then also saying, you know, but I'm going to do what you want in the end. And we have to kind of make sure that we are loyal to our clients. Moving on with more client considerations, I think I'm so glad that Gabriella spoke first, and we had her kind of lay the foundation in terms of all the issues and things that are going on in a survivor's mind and heart and emotions, because that is really important as you start to work on their case, specifically with things like drafting declarations or maybe responses to discovery. It's going to take some time. The narrative is going to be disjointed. There's going to be a lack of memory for, you know, whatever reason. Maybe they were forced to take drugs and they blacked out. Maybe, you know, as a survival technique, we do, you know, in order to move forward with our lives, we block out traumatic experiences so we can move forward, right? So there's going to be chunks that they might not remember. Gabriella talked about triggers that might come up in the day before trial. Oh, I remember something. And so you really want to give yourself and your client a lot of time for declarations and putting together the facts and the timeline. And that means if you have a response deadline or a reply deadline or a discovery deadline, you're working back from that deadline with plenty of time. So you're not stressing yourself out or your client out even further in trying to get this all together so you get that filing deadline on time. Know that they might need to take breaks and just be sensitive to that. And also being sensitive to explain what is relevant in a declaration and what isn't. I know our jobs as attorneys to say, here's your strategy, here's what's relevant, here's what I need. So, you know, if a client wants to talk about their, you know, entire timeline and start from day one, you have to find a sensitive way of saying, I understand that as your advocate, I get that you've been through that, and I thank you for sharing your experience with me. But, you know, in terms of what I need for this declaration, that's why I've removed this for now, and we're going to go forward with these facts and not all the facts. Speaking of responses and replies, you want to give your client a heads up that your motion is going to be filed and it needs to be served to the other side, who might be their trafficker or who might be their sex buyer or, you know, an abuser. And that they're going to read that and they're going to respond, and they're going to have an opportunity to respond. So I like to say that if you have staff, you know, at our firm, we have paralegals who send things out, law clerks, file clerks who help send things out to clients, to give them a heads up too, to just not shoot an email saying, oh, here's the response, please let us know your thoughts. That you might want to look at it first. You want to call the client and prepare them and say, let's go through this together, because you're not going to want to read this probably on your own. And I can explain a lot of this, that this isn't irrelevant and it's going to be okay. So just advising your staff on the dynamics of cases. Let's see. Okay, as mentioned above, we do want to talk to them about what to expect at court, whether it's going to be virtual or in person. Who's going to be in the courtroom? What's the role of the bailiff? If you can, you know, if you're in person and you can tell the bailiff, hey, these are the parties, this is the situation, we're staying apart, please help us enforce this, you know, especially if there is a restraining order, then I think that also could help a client's nerves, ease their nerves. Explain the flow of the hearing. You know, it's going to be moving, opposition, reply. Some judges are very stringent about the timing on that and others aren't. So if you get cut off, you know, that's why. Why testimony is helpful or needed. You know, why am I making you go on the stand to do this? And, you know, not making you, but, you know, why are we choosing to put you through this so that you can testify today? They're allowed to have an advocate. So we should make sure that, you know, that they can have someone there as a support person. And then making sure that they have access to appropriate clothing. Unfortunately, we live in a reality where people make snap judgments and have implicit biases. And so approaching that conversation of sensible, respectable clothing in the courtroom is something that you might want to talk about first. Fortunately, here in San Diego, we have Shariah's Closets, a nonprofit that Free to Thrive works with, and they provide clothing for our clients to appear at court. So if you can link up with a nonprofit that's local like that with you, I think that would be really helpful to kind of ease your clients' tensions and getting ready for court. So I want to talk about testimony preparation. So when you're actually in court, we want to talk about direct and cross and preparing your client for both of those. Again, this is part of setting the expectation ahead of time so what your client knows what to expect. On direct, you want to remind them, here are the topics I'm going to be asking you about. Be prepared to review your declaration and kind of talk about these things. You want it to come off natural. And, you know, this isn't a platform for you to give an entire life story, and being able to, sensitively say that. You say, I understand you've been through a lot and I appreciate you sharing that, but I want you to know that not all of this is going to come out in my testimony. So, in your testimony. So if I don't ask you these questions, this is why. You know, I'm not forgetting it, and I'm not, disregarding or dismissing something. Advise them to always speak slowly for the judge and the court reporter. Don't talk the way I'm talking right now, which is like a mile a minute. So I make sure that we have time for everyone, but much slower so that everyone can hear, and to never talk over the judge or the other party, right? Because you don't want to come off as combative or fighting something. And we can talk about redirect in a second. And to pause after each question so that, the attorney has time to object to the question that was asked, and to allow you time to think about what your response is going to be. It's okay to take your time. On cross-examination, you want to advise them to just be ready, that it's not going to feel good. People don't like being cross-examined, and especially when it's from their abuser or a perpetrator of some sort, or their attorney. It's just not a fun experience, but it's necessary in order to uphold justice and to get certain facts out to the judge. So you want to advise them to do one-word answers. Yes, no. Don't offer any other additional information. Just say yes or no. Again, you want to pause so that there's time to object. If you don't understand the question, it's okay to just say, you know what, that's a lot of legalese. And we heard from Gabriella that it is. It's a lot of stuff that's going on really fast that you don't understand, and it's okay for you to ask for the question to be repeated. You're also going to want to fight the urge to challenge the question that's asked from you, or to give any type of attitude. And what I like to say is that, it's my role as the attorney to be the fighter in this case. You're here as the witness to provide the facts for the judge. I'll be the one to object, and I'll be the one to redirect you, because I'll have an opportunity. So when the opposing counsel says something like, you left the house in 2013 and you never returned, correct? Yes. And you haven't seen your children since 2013, correct? Yes. That's going to hurt. It's not fun for, your client to sit there with that feeling, and you want to say yes, but. I know your case and I'm your advocate. So on redirect, I will ask you to explain those answers a bit more. So just knowing that that's going to come, and that will be a lot better than, yes, but, and then trying to fight with the opposing party or opposing counsel. I also just like to say, I don't know what other attorneys think, but, like Gabriella said, the court is very formal feeling. It's just a weird place to be in. You don't know what's going on. Everything's moving kind of fast. And, I think sometimes when people are nervous, they kind of shut down and turn into robots, and that, they're afraid to cry or just to feel emotional. And so I always remind clients, if you feel like crying, that's okay. There's going to be tissues. We'll take a break. We'll take a recess. And to just remind everyone that we're humans throughout all of this, and that if something is emotional for you, then that's okay. Don't repress that if that's going to make you feel even more anxious on the stand. And that's just my advice. I don't know what other folks think. So now we're going to go into kind of each specific little issues. Quickly on just divorces, I just wanted to point out that in California, we have something called the summary divorce. It requires cooperation between both parties, but it's, if there's a certain amount of assets or debts that are less than a certain amount, there's no kids, there's no real property. It's a really simple way of proceeding forward with your divorce. And so I recommend that for cases if that's possible. Some other financial considerations is that you can still get attorney fees for, even if you are a pro bono attorney. And if you're not subbed on the case yet and your client is starting the case, you can consult with them on how to request for a fee waiver for filing petition response, because it's $430 to file. And so if you can show that your income is low enough, then you can show that that should be waived. So that's super helpful. Child custody. So this is one that I think is probably the most important especially, if children are involved. Let's skip ahead. Okay, so starting off, just, big picture level, I think most attorneys agree that there is a best interest of this child standard, probably throughout many states, whatever you call it. And that umbrella, it's a broad umbrella, right? What does that mean? And that's been developed through case law and family code, or code sections. And one of the biggest things that is in the best interest of the child is frequent and continuing contact with both parents, right? We want to do 50-50 custody whenever possible, and courts are going to want to do that as much as possible. But given, absent, there aren't any major considerations that need to start filtering in. Now, when you start filtering in, the age of the child, of course, a 6-month-old baby who's breastfeeding shouldn't have 50-50, right? Maintaining the child's status quo. What are the kids used to in terms of the parenting schedule, and how can we maintain that for them? In terms of comfort for them, any special needs for the children. Jan's going to talk about domestic violence issues, and so on and so forth. So I only say that because some of those will involve a history of trafficking if it affects the children, right? And so we're going to want to know when to present evidence of trafficking and when not to. For example, I had a case where my client hadn't seen her children in several years the father of the children was her trafficker, and she had lost custody way back when, before she didn't have an attorney. And so she didn't see her children for a long time. So I helped her. My job was to help her get reunified with her children and get some type of visitation back and get them, seeing each other and knowing their mom again. But by the time that happened, they were in their teenage years. Right. And so I had the judge tell me, I understand what you're trying to say. I get that you're saying that there was trafficking in the past, but we're not here to put him on trial for that. My job as the judge is to make sure the best interests of the children are being met, and that, at this age, is it okay for them to see their mom, and what do they want to do in terms of that? What should we shape in terms of what is in the best interest for them at their age, and given the fact they haven't seen her in multiple years. So it was really hard for my client to swallow that, in terms of, she kind of felt she was being punished. And, I had to explain to her that we're not putting him on trial for trafficking. And yes, that happened years ago, but at this point, what is in the child's best interest? Is it to just go automatic 50-50 with both parents after not seeing them? No, that's not, unfortunately. And so it's hard. It's a difficult position to be in, to explain to your client that that's where the judge is coming from. It doesn't mean you did anything wrong, and we can work with that. And so I'll give some examples of that as well. Actually, we can dive into that right now. We're going to talk about, what happens when the other parent is more stable. And for example, we might have a client who is coming out of jail or prison. We might have a client who doesn't have a job and maybe doesn't have funds for their own apartment. So they're renting a room, say, with several other roommates, adult roommates. Or they don't have transportation, reliable transportation. They're using public transportation, for example. So what do you do with someone who's fresh out of jail or prison? If it's been a short amount of time, I would argue, what was the status quo before that? If it was just a short interruption, let's go back to what the kids are used to. If it's been longer and there's needing to be some type of reunification between the parent and the kids, I would ask for a gradual step up and say, today, Your Honor, instead of having us to have to come back several times, can we talk about what's an appropriate timeline to get them back up to 50-50, or just get her increased so she's not stuck with this minimal visitation and has to start the process all over again to ask for more. And then you can also ask for reunification therapy with the children and the parents to kind of work through that increased gradual step up. I mean, there's a lot of ways to be creative with that, to let them know that this is what we're working with and we're trying our best. Say your client doesn't have their own apartment. Well, you can ask for their visitations to be during the day if the court or the other party is worried about who are these other adult strangers living in the house. Give them as much daytime visitation as possible. Give them visitation to happen maybe not in the apartment, but other places like parks and other places. Ask for a different schedule to be confirmed or ordered now upon mom moving out to her own apartment or moving in with a family member, that's trusted. A lot of courts don't like to look into the future and put conditions on, but sometimes you can get creative and get a judge who will say, okay, if mom moves out and has her own apartment or is living with her mom, for example, then, we'll change the custody schedule to that at that point. If they don't have transportation, ask for the other party to be the one that has to pick up and drop off for the exchanges, right? Or ask that a reliable family member or friend can be the one that does the transportation. So it's important to note that, a client's financial position in life shouldn't be a barrier for them to have custody, right? That's not constitutional, but it's going to create certain barriers that are just realistic in terms of logistics and the safety of the children. But we have to just, as attorneys, be creative and find ways to help a client who might be in that position, because more often than not, that might be the situation. And I just put a note about minors counsel in California. If there's a really high conflict case and the parties are going back and forth, dad's saying, mom's a prostitute, she's on drugs, and mom's saying, no, that's not the case, I was trafficked, here's what I've been through. You know, a lot of the times the court for custody can say, let's get a minors counsel appointed that can advocate for the best interest of the children and kind of get down to the point so the judge isn't just, you know, getting this conflicting testimony back and forth and getting even more confused. Okay, so I want to talk about, this is my last slide before Jan, I believe. So I want to talk about child and spousal support and some specific considerations here for being trauma informed and being able to, when, you know, a history of trafficking might be relevant. First, I'll say for any time you have child support, I really suggest using what we call Department of Child Support Services. It's the county or state public entity that sets support, collects support, and enforces support orders. Right? In California, it's mandatory for any parties that are on cash aid, where the county attorney is going to represent the state and the county's interests, which is to always make sure that the party who should be getting child support gets that child support, right? So if that's your client, that's a really great way for them to go. The county's not going to represent them, but they will be aligned in what they're advocating for, right? In their final goals. But there are going to be issues about being able to prove income available for support when you're talking about child or spousal support. In California, if this is a dissolution, we start off all cases with preliminary disclosures where your assets, let's say your income, your expenses, and your assets and your debts are on these forms, and they're both exchanged between both parties. So everyone understands what is going on, what is the financial situation of this case. So that could be helpful in terms of figuring out income from the get-go if you have a dissolution. But sometimes, you know, the other party's income they might not have any documented evidence of that, right? They're not going to have a W-2 wages. They're not going to have pay stubs. Probably maybe haven't filed tax returns in a long time. They might be getting paid under the table. And if they are currently trafficking other victims, then yeah, of course, that's not going to be reported to the IRS, any money that they're making off of that, correct? So it's going to be really hard to sometimes identify what their income is, and you might need to be doing some additional discovery in terms of bank statements to see cash deposits. If they're working under the table, you might want to see some employment contracts for that, and anything else that you can find in order to prove their income. And note that sometimes your client might be the one who's in that situation as well in terms of her income and being able to show what that truly is. And your client might not be employed, so we'll discuss that later. And if they are, they might be getting paid under the table as well. And they might not have any bank accounts or financial accounts to track you know, their income and how they've, you know, pay their expenses. They might have operated in cash their entire lives. So that's just something that you're going to want to be aware of. It's not as simple as regular divorce cases. In California, if either party is not earning to their full potential for children, for child support or spousal support, the court has the ability to impute them with income, right? And that imputation is going to be based on their ability to earn and the opportunity to earn. So there's some special issues that we can talk about in terms of trafficking survivors here. If imputation happens, which is imputing them with income, while they're being trafficked, or shortly after they have, you know, just coming out of being trafficked, then you will want to put that before the court. That is an example of a time where you're going to say, yeah, Your Honor, my client didn't have the ability or the opportunity to earn because she was being trafficked by either the other party or someone else who was taking her money from her. And of course, she didn't have time to just go get a part-time job. And even if she did, you probably would have taken that too. So you're going to have to show why that person doesn't have any income or ability to earn at that time. Or you can have a situation, unfortunately, which is true for many survivors, where they have a criminal history. And it's a barrier for them getting employment, right? After you do that background check, the employer says, no, thank you, we're not going to offer you this job. So you're going to want to put that before the court as well. My client has a criminal history from prostitution, loitering, whatever it might, vandalism, whatever it might have been in the past. And this is a barrier from her having opportunities to earn. And what I would even do is preemptively give the court her job contacts, which is, a record of every time she's applied for a position, when, and what the result was, and let the judge know, here's how many times she's applied, and here's how many times she was denied. So that, I think that would go towards someone's opportunity to earn. And until they can get their record vacated and, taken off so that that doesn't show up in a background check, or luckily find an employer who will employ them, they're going to have a problem with that. And I think it's important to bring that to the judge's attention. The resulting child support order, I want to make sure that sometimes I think a lot of family law attorneys know this, but before you're requesting child support, you want to make sure you can run numbers in terms of what is the support going to be. If your client isn't the one with primary custody at the time, they might end up being the one who has to pay support, especially if the court, maybe imputes both parties with minimum wage, but it's not a 50-50 custody, so that timeshare makes it so that your client is the one who has to pay. So you want to explain that to the client and say, we don't want to have a situation where you're either paying the other parent, especially if they are the trafficker, having to pay them support, and that you don't want that to be accruing arrears, because those are going to be, you're not going to be able to get rid of those. So just knowing when you want to file and talking to them about that ahead of time, that could be a situation that results. And then last, I want to just give a few points. Dan's going to talk a lot more about domestic violence, but in California, if there is a domestic violence finding by either family court or criminal court in the past, that can be a block to that perpetrator who, committed the domestic violence. It could be a block from that person requesting spousal support, right? So they can't ask for spousal support from the spouse that they abused of their entire marriage. That makes sense, which is great. So you'll know that if that is a situation and you do have a prior finding, then you can use that to block spousal support from your client. And that might be a reason to explain to your client why you wanted to go forward with a restraining order if they're hesitant about it. Actually, in California, you can also block the other party from getting your client's retirement that's accrued during the marriage if they have been a victim of spousal abuse from their spouse. And so that's in terms of the community property division that we have in California. But those are just important topics to keep in mind. And I know I went a mile a minute, so I apologize for talking so fast, but Jan does have some great things to say. So Jan Maiden is up next, and she's gonna be talking about some special considerations when working with survivors in family court.
Thank you, Mary. Welcome, everyone. I just wanted to acknowledge the fact that we have a lot of non-attorneys here, and I want to let you know I was a family law paralegal for 5 years before I went to law school, graduated at age 50 with a law degree. Also, I spent the first 5.5 years as an attorney at the San Diego Family Justice Center, representing victims of domestic violence. I worked there and continue to work closely with DV advocates and a number of nonprofits. So I have a lot of experience in working with a lot of different kinds of victims, and I have taken some pro bono cases from Free to Thrive. My contact information, all of our contact information is at the end, and I am always happy to answer any questions, mentor anyone in any way I can. This is really important work, and these survivors really need our assistance. Obviously, when you're looking at working with someone who is a victim of human trafficking, substance abuse is a major issue. It's often self-medication. And as Mary said, and maybe Nikki said, it can create problems like memory gaps and so forth. They just won't remember what happened because they were using. It also creates problems for them if they're going into court and seeking custody. And I've had that happen frequently if they can't get a clean drug test. Also, the other party may be a substance abuser. Proving it may often be difficult. I've had cases where one party's ordered to take drug tests and not another. California, you can only order, the court can only order what we frequently call P-test. You cannot get hair follicle tests, which go back a lot further. Obviously, again, domestic violence is a major issue, and it affects our clients in many ways. And if they've been exploited through human trafficking, their ability to function, their records, all of that, as Mary and Nick have gone over, can be difficult. Trust issues, they may not trust you, and they may not obviously trust the other party, especially if it is their trafficker or someone that they've been involved in through their trafficking situation. Clients will frequently turn on you and accuse you, not frequently, but may turn on you and accuse you of siding with the other party or not listening to them. It's a very fine line. I have actually had to stop representing some clients who no longer trusted me because I felt that there was a breakdown of our attorney-client relationship. And in California, you can do that. It takes time for many people to develop that trust. And you just have to be really aware of how you, whether you're a DV advocate or an attorney or whatever your position is, how you work with that client. As we've stated, many of them have mental health issues. Many of them may suffer from PTSD. Going to court, seeing their abuser, whether it's virtual or their abuser or their trafficker, or whoever that party may be, may bring back PTSD issues. And that can be really traumatic. I know that if you have not been trained in secondary stress disorder or vicarious trauma, it will affect you as well. I don't think we got that in the slides, it just occurred to me, but the work we do can create vicarious trauma for us as well. And you need to be aware of that. Immigration, obviously many of our clients may have immigration issues, and you need to be aware of that as well. So all of what we're trying to say is that trauma that they've experienced is always got to be at the forefront of the work that you do with the client. Okay, Mary, next slide. So the crossover issues, as we've alluded to previously, there may be criminal cases against either the client or against the other party that can affect the case in family court, especially when there are custody issues. The first thing I always do when I do my client intake is trying to find out what I can about both my client. I always say I don't want any surprises. I don't want it to walk into court and find out you had 3 DUIs you didn't tell me about, or vandalism or something else. And I always try and research the other party and make sure that I have all information on them, whether it's criminal records. It's amazing what I know we're all finding on Facebook, social media, Twitter, Instagram. You know, whatever you can get about the other party is helpful. The case may involve a dependency matter. I have had clients in family court where the children are in dependency court, and there's 2 cases going simultaneously, but the family court can't make any orders regarding the children until they are released from dependency. So I remember a client who was on meth and her husband was on meth and the children were taken away. And I remember having to tell her, you know, you have to choose whether you want meth or the children. And eventually they both got clean and they both got the children back. But that obviously, you may have to be involved with the dependency court. Immigration is a major issue, and we'll address some immigration issues later. But obviously, if your client doesn't have legal status, that can affect matters. It used to be that the other party would often bring up, or one side would bring up against the other, well, they don't have a valid driver's license. And the reason they couldn't have a valid driver's license was because they didn't have legal status. That's no longer an issue in California. I don't know about what other states are doing about driver's licenses or documentation for those who are not legal, but it can even come up in a custody in that kind of roundabout way, and it can be another way that the other side may use it against your client. So let's go on to the next slide. If the client chooses to have a restraining order, or if they already have one of the things to know is that all restraining orders issued by a court have full faith and credit in all 50 states and the territories. So if your client comes to you and has just recently relocated from Virginia and they have a restraining order, you need to know what procedures there are in your jurisdiction to register that restraining order and make sure that it is enforced. In custody issues, domestic violence plays a major role. We have two codes sections in California. One is 3044, which says that there is a presumption against giving someone where there has been a finding of domestic violence in the past 5 years. It does not require a restraining order, but there is a presumption against giving that party joint legal or physical custody, and the perpetrator must address certain presumptions to overcome that presumption, whether there's been further domestic violence, whether they've taken certain classes, whether there's been all kinds of things. And Family Code 3044 is a major issue, and many times the other side will accuse the victim of seeking a restraining order to get a leg up in the litigation by getting a restraining order against them. The other issue is California has another law that looks for the best interest of the child, and one of the issues in looking for the best interest of the child and the child's health, safety, and welfare is whether there has been domestic violence. So that comes up. Mary talked about spousal support as well, that a perpetrator cannot receive spousal support. One of the things in California is restraining orders. There is law that says that the court can and should address child support, child custody, and spousal support for the victim. However, it will depend on your jurisdiction. Locally here in San Diego, we find that our judges will make custody orders, but they will not generally make spousal support or child support orders in a restraining order, and require you to file a separate case, whether it's a divorce, parental relationship case, etc., to get those remedies, even though the law says that the judge is supposed to do that. The other thing I want to bring up, because it's become a major issue in the last few years, electronic harassment, social media, Facebook postings, releasing emails, posting inappropriate photographs. All of this is keeping lawyers really, really busy and making lots of money for those who do that kind of thing. I have won many, many restraining orders based on text messages, social media posts, etc. And so you want to be aware of that, and you can actually, here in San Diego, we have special electronic harassment orders that have been put together by our supervising judge. So one of the things I want to mention is that your client should always keep text messages, take screenshots, keep any records that they have, print out or take photos of Facebook posts or anything else, because it may be something that can assist not only in a restraining order case, but in any aspect of a case that they have with the court. It becomes invaluable evidence. Go ahead, Mary. So who can get a domestic violence restraining order in California? And a domestic violence restraining order begins in California with what we call a temporary restraining order, which is applying to the court for orders without giving notice to the other side. It does require what we call a special relationship, which are spouses or former spouses, cohabitants or former cohabitants, people in a dating or engagement relationship, parties who've had a child, and as we all know, that requires 30 seconds, and that may have been one evening out where they hooked up, and they could be stuck together for the next 18 years. Consanguinity for the attorneys, that takes us back to our wonderful days in law school. So it can be your parents, your step-parents, your grandparents, your child, your grandchild, your stepchild, your siblings, and your in-laws. It does not include aunts, uncles, cousins, ex-in-laws, or the most often seen, your ex's new significant other. Those all fall under the civil harassment restraining order as opposed to the domestic violence restraining order here in California. Mary? So, what can you obtain in a domestic violence restraining order in California? You can get personal conduct orders to not strike, harass, attack, molest, destroy the personal property, make harassing phone calls, disturb the peace, a stay away order. Now that varies by jurisdiction. In San Diego, it is a standard 100 yards, but it's different in different jurisdictions. Removal orders, you can actually have someone removed from the home. You can get the custody orders, as we've discussed. You can get support orders. You can have property control of an address, of a vehicle, which is the one we most likely and frequently use. You can have rights to protect pets, which was added several years ago, knowing how pets can be used as ways of controlling victims, victims who won't leave a home without because they can't take a pet, etc. There are definite firearms prohibitations that include federal prohibitations. You have the right to record communications under a restraining order, which in California is a two-party consent state. So if one party is recording without the other party's consent, it is not legal, but with a restraining order, you can record. You can have control of your cell phone and cell phone accounts. So a restraining order can do all of that. The standard of proof in California is the preponderance of the evidence, which for the non-attorneys is pretty much more likely than not, or 51%, or you've tipped the scales. The difficulty with a civil harassment restraining order, which we discussed, and it may be that your client needs a restraining order against her trafficker, but she doesn't meet any of the criteria for a domestic violence restraining order. A civil harassment restraining order in California is clear and convincing, which bumps it up from 51 to about, we like to say 75%. And I've been discovering in my work in San Diego that our judges want much more independent documentation, whereas restraining order, DV restraining orders are often, I said, you said, he said, she said. Civil harassment restraining orders have a higher standard of proof. Okay, let's move on. I just saw the time. Judges may not find trafficking relevant in terms of a restraining order. The issue in a restraining order is, was there a past act of violence, and did they meet the relationship? So your client may want to bring up issues that you have to explain, whether you're an advocate or an attorney, may not be legally relevant. One thing to know is in California, we have Family Code 6306. Most people don't realize this. The court receives a report on the respondent of their criminal history that they get from all of the databases. Some courts do run criminal history on both parties, but obviously, even if your client has a criminal record, it doesn't preclude them from having the protection of a restraining order. And as we all know, a DVRO is a piece of paper. People get killed even when they have them. Here's some information. I'm not going to go over it in detail. but survivors of domestic violence, sexual assault, and human trafficking can break their leases in California. We're giving you some information on that. I'm not going to go into detail about it. Go ahead. Unique issues that come up in domestic violence. California does say that the Family Code 2210, the Civil Discovery Act, applies, but there was a case in California in 2005, Thomas v. Quintero, that said that in a footnote, it's footnote 11, that because of the speedy terms of discovery of restraining orders, that there shouldn't be any discovery in restraining order cases. It has also been applied by some judges into domestic violence restraining order cases. There was also a case, S.A. v. Maiden, yes, that's me, from 2014, which was what we call an anti-SLAPP case. I was sued by the other party in a domestic violence case, and the court said we want to protect attorneys from not having, from any chilling effect that a fear of representing victims of domestic violence. With depositions, sometimes the opposing party will want to take a deposition, and whether it's in a restraining order or just in a issue with human trafficking victims, you have the right under the law to go and get a protective order that controls who is at the deposition, if, you know, what, any way that you need to protect your client. It might be just too traumatic to have the trafficker in the same room. They can be ordered to be in a separate room watching on video. I mean, there's different ways to do it, but be aware that there's a lot of issues about discovery in domestic violence and trafficking. The thing I want to say about immigration is in California, we now have evidence code 351.3 and 352 that precludes someone bringing up immigration status in court. It requires an in-camera review by the judge. What we're doing in San Diego is if someone has filed a pleading that says, makes some kind of allegation about either party's immigration status, we are redacting it and replacing it in the file. So again, it's just a red flag. If someone comes into court and says, I don't have status, or she doesn't have status, you immediately have to stop everything, raise evidence code 351.3. Next. Pro per issues. They don't understand the law. Your client, they don't trust attorneys. They accuse you of everything. You also have to prepare your client that that person's going to be in court and may be cross-examining them, and that the judge may give the pro per an awful lot of latitude because they're pro pers. Again, just some trauma-informed issues that you have to be aware of. Next. So you also have to decide whether you want your client to testify. As we've discussed, they may have memory issues, they may be completely inconsistent, they may not present well. So that creates problems if they are going to testify. And sometimes you may want to address those issues right at the beginning of your testimony. Language interpreter issues, which are getting more complicated with our virtual hearings. It's taking me 3 times as long. I've been doing a number of hearings because I work with refugees from the Middle East when we have to have everything interpreted virtually. Sometimes it is better not to file a case in the court if you can, from a number of reasons. You may not want to file a restraining order because then there can be orders that can affect your client's ability to move with children or to do other things. It can escalate and create a bigger risk of abuse to your client. If they don't get the restraining order, your client may be affected emotionally. You may want to file a custody motion if children are involved versus a restraining order. So there's all kinds of things, and always feel free to talk to someone else or check with Mary or me or Nick, and we can always be happy to help you on that. Mutual restraining orders may be coming up. There's specific laws in California regarding how the court is to address those. You want to make sure they're heard on the same day by the same judge. Sometimes the abuser, trafficker runs to court and gets a restraining order against the victim. We've all dealt with that. There's also issues on whether you want to continue a restraining order. If your client is the victim, there's generally no detriment to continuing the restraining order because they have the temporary restraining orders stay in place. I'm racing at this point, Mary. Okay, I think that's next slide. Nick, you're back on.
Thank you, Jan. So what I want everybody just to sort of keep in mind is lawyers are storytellers. Our job is to tell our client's story. And in the context of human trafficking, very frequently what we are doing is we are retelling a story that is very familiar to people, but very detrimental to the survivor of trafficking. Movies such as Taken, portray human trafficking as something to be something that happens to pretty white girls in foreign countries. Movies such as Pretty Woman makes trafficking seem voluntary in nature. What we are doing is we are telling a story about exploitation and how it affects a person. And when we do that, we have to really keep in mind a lot of client dynamics. One of the things that lawyers are notoriously frustrated about, just with clients in general, especially in the family law space, are missed appointments. The reality of trauma victims and trauma survivors is that life is frenetic and hectic. And then we have to hold space to understand that, we're serving them, our time is their time. Nearly every client I've ever come in contact with has a degree of self-blame or minimization. And sometimes the adversarial nature of these types of proceedings makes that client feel guilty. And consequently, they will sometimes take it upon themselves to lessen the blow of the adversarial proceeding against their abuser or trafficker by either blaming themselves or minimizing their experiences. Lack of documents is another big issue that you have to prepare for. Most family law clients are missing documents in general, and this is especially true for trafficking survivors as well. Sometimes they may not have access to documents that they know exist. Sometimes they do not have financial documents to back up or reference. Frequently, they're unaware of debts that may be owed or in their name, whether or not their social security number is being used by another person. Sometimes clients may not have a case number to even reference. And so the first step is really pulling the file and just figuring out what can be done in their case. And that can be a cost barrier as well. Most clients have very urgent non-legal needs. As Mary discussed, how do you address a client's custody concern when they do not have an apartment or they do not have reliable transportation? If a client doesn't have shelter or food or clothing, their legal needs will not only seem insignificant to them, those may actually be barriers to getting the desired outcome. Indecision is a dynamic that we frequently have to grapple with. A client may either not know what they want, or they may frequently change their mind. And so one of the things that we do is we take great pains to explain each step and where and when finality happens. And if it's possible, we try and craft orders that'll preserve a client's right to choose. Our goal as attorneys for trafficking survivors is to empower them to make decisions so that the legal system doesn't force them into decision-making that they don't want to. And so when Jan says sometimes it's better not to file, that's something that we're cognizant of. Is this a possibility that could force a client into a decision-making paradigm that they don't want to be in? High levels of stress and anxiety. This is most frequently attributed to past trauma and unfamiliarity with the court system, as well as the adversarial nature of the proceedings. So attorneys really do need to be mindful that clients medicate their trauma. And one of the things that I learned in this line of work that just blew my mind was women don't use meth at night recreationally, especially homeless women. They don't use it to get high. They use it to stay awake, because the most vulnerable time for them on the street is at night, in the dead of night. And when you start to understand some of those dynamics, telling their story becomes a little bit easier to explain. Yes, they use meth. They don't want to be using meth. And these are the steps they're doing to get off. but there's an explanation for why that might be in their past as well. And memory issues, as Gabriella spoke. She talked about how during her trauma, she would self-medicate. And it's very common for victims and survivors who have experienced trauma to medicate and to try and forget. Our brains are designed to help us process out bad things that happen to us. I would encourage all of you who are listening to this to check out our website for our past trainings. We have a great presentation on trauma and how it interacts with the legal system and with our client base. That was presented by Dr. Brittany Greenbaum and Jamie Beck, who is our president, managing attorney, and founder of Free to Thrive. And I'm going to introduce Jamie now to talk about some of our upcoming trainings as well.
Hello, everybody. Thank you so much to our speakers, and thank you not only for doing this training, but thank you for all of your work on behalf of our clients. Each of you has given so much of yourself to help our survivors, and we're really grateful for that. So Nick just mentioned our past trauma trainings. Take a look at those. I know Jan mentioned specifically vicarious trauma, and we actually just did a training on that. So please do check out our website. Those are all there. And we're actually planning another trauma training coming up soon, shooting for August for that one. In the meantime, we have a training on vacature coming up July 15th. Now this training really is geared towards attorneys, both public defenders, survivor attorneys, and prosecutors, and to really help them take a deep dive into vacature and what that is. For those who don't know what vacature is, that's a special law that allows survivors of human trafficking to clear their records that are related to their trafficking. And as this came up a lot today about how survivors have criminal records and all the different ways that holds them back, certainly family law cases is one. So if you are interested in learning more about that, please do register on our website. And thanks again to our speakers. And we're now gonna really quickly, before we go on to our Q&A, which we're going to jump into in just a second, if you have questions, feel free to start typing them, because Nick's going to be moderating that in just a minute. But be sure to check out our social media pages as well. And now with that, I'll turn it back over to Nick, who's going to take some of your questions.
All right. So Sabrina asks a question asking, is it better to file a claim for vacature of charges related to trafficking before family court? Or can you bring this up during family court and have the same judge help with vacating these charges? That's an excellent question. I would normally, as we do the Q&A, I'm gonna field these questions out to Jan and Mary, but I do wanna answer this one specifically because we will talk about this in the vacature training. One of the challenges we have with vacature is actually ensuring that the client's record is cleared after we get the vacature petition granted. Sometimes there can be a lag time between the Department of Justice that produces that criminal report and the order from the court ordering those charges, cases, arrests removed from their record. Sometimes you may not have time to go through the vacature process prior to family court. Can you have the same judge help with vacating those charges? I don't think so. I don't know that it would be in the same realm, because criminal court's a court of law, family court's a court of equity, and that would need to at least give the prosecuting agency in the jurisdiction where you're seeking to clear those charges opportunity to either stipulate to the vacature petition or respond adversarially to the vacature petition. So probably won't be able to have the family law judge do that. Though I think it is worth noting, if you are in California, that Penal Code 236.14 is our vacature penal code, and that if the judge is going to accept certain facts as true in making findings, they ought to feel safe disregarding certain criminal record that they might have come across from a client, though they have not been vacated. Elizabeth asks, how do you prepare a client for cross when the respondent is a violent trafficker appearing pro se and gets to question the client? Jan, would you like to talk a little bit about how you can either get around this dynamic or prepare your client for this dynamic?
I mean, just the bottom line is it can happen. And so you just have to work with your client, whether there's an advocate, whether there's a therapist, whatever it may be. It also will depend on the judge. You may ask the judge to do the questioning. Sometimes the judges will do that. Sometimes they just do it anyway because they don't want to have the pro per do it. Sometimes you can say to the judge, Your Honor, my client, we're requesting on behalf of my client that you do the cross. The other thing is just, you tell your client this is going to happen. You can practice. You can tell them if they need a break, if they start crying. I mean, I've had to ask the court to go into recess so my client can just step outside and pull herself together. Sometimes what also happens is some of our clients are really angry and hostile. I've had them yell at the judge. I've had them screaming. I've had them yelling at the other party. I've had to have bailiffs intervene. And not all judges get the dynamics of why they're so angry, and that this is one way that, rather than being the shriveled up little crying mouse, sometimes it comes out as anger. And the more time you can practice with your client and come up with hypotheticals, but there's no getting around it. The pro per legally has the right to cross-examine them. Mary, do you have any comments?
I would just add that, if it's going to be the pro per doing the question, it's not likely that they understand how to ask appropriate questions, and that I'm the one who will object and block the questions. So that's why you want to take the pause before you answer and just answer the question with yes or no. And they're likely not going to get the answer that they want because they didn't shape the question correctly, right? So it's either going to get objected to, or you're going to say yes or no, and they're not going to be that successful, which I know that doesn't quell necessarily the fears of even having to be questioned in the first place, but if that provides a little bit of they're not going to do well. So, give them their one word answer and let me handle the way in which they ask the question. And that might give them a little bit of hope of okay, well, we're going to get through this. So. Right.
And the other thing is when the pro per is incompetent in asking questions, that is often when the judge will take over or tell the pro per, sir, you need to rephrase the question, which if you're really fortunate will just tick off the pro per and they will lose it in court or become even more appropriate or hostile or argumentative, which is like giving them some rope to hang themselves. But I have had clients where the pro per is very bright and manipulative and goes on and asks questions that the judge allows, and your client just will have a very hard time, and there is no getting around it.
Yeah, I think that's a great answer. And just sort of to tie in what Jan said in her presentation, this is one of the strategy considerations that you have at the beginning of the case when you're determining A, whether to file, or B, whether, for example, in a domestic violence restraining order, you're asking for an evidentiary hearing where testimony is going to be presented. Is this something that you want to subject the client to, and does the risk or potential negative outcomes outweigh the potential benefits that one could get by going down this path?
But Nick, I'm sorry, the other side also has the right to ask for an evidentiary hearing.
Yeah.
And whether it's custody or whether it's any restraining order or child support, they can still request an evidentiary hearing, and you have no control over that. The judge will most likely grant that request.
And that would be Family Code 217 here in California. If a party does request that, right, then the judge has to set an evidentiary hearing. I'm not seeing any other questions in the QA slot. If anybody does have any questions, now would be the time to answer them. But I do want you all to know, Jan has been a fantastic mentor to me and Free to Thrive, as has Mary. They are super generous with their time. And our information is up on the screen. If you do want to reach out to us and ask us any questions directly or speak to us on the phone, please do give us a call. We always look forward to talking with people about these issues, and are always happy to help. So I'm not seeing any more questions this time, so we're going to let you go. This is recorded. This recording will be available for free on our website. The materials that we referenced in this presentation will be sent out following this presentation. And thank you all so much for attending. We really look forward to connecting with you in the future.